We're going to be discussing two issues through the vehicle of two cases. The two issues are, first, the longest, most argued about issue, and that is the balance of national and state power. We generally associate that with the word federalism. What does the federal government get to do, and what do the states get to do? The second issue is the meaning of human freedom and the issue of racial equality. Henry Steele Commager, a number of years ago, in the middle of Franklin Roosevelt's administration, I believe, gave a view of the Supreme Court that was widespread. Hardly a word had ever been spoken by that court, he said, in defense of liberties, minority rights, equality. Judicial review was a drag on good government. And things look very different now after Earl Warren and years of finding new fundamental rights. But we should not forget that the Supreme Court's early history is a much more controversial, negative pattern of performance, and one that we frequently shudder to read and consider. And that's going to be true of the two cases I look at today, Prigg versus Pennsylvania and the infamous Dred Scott decision. Prigg concerns the Fugitive Slave Clause, which says that states have a constitutional duty to return escaped slaves, without using the word slaves, to states where they're bound to work for someone else. Now, this clause was a response to a 1772 English case called Somerset versus Stuart, in which the King's Bench ruled that a fugitive slave was emancipated merely by reaching and touching the sacred soil of England. The spirit of liberty is so pervasive in England, the court reasoned, it could not tolerate slavery. And from that, we got a rule that did govern American law. Slavery could not exist unless by operation of state law. A state had to pass a slave code, what jurisprudential scholars call positive law, to support it. Otherwise, slavery is presumed not to exist. James Madison acknowledged this at the Virginia Ratifying Convention. There's a presumption of liberty and freedom in the land, and only positive state law could make it otherwise. Now, neither of these cases I'm about to discuss consider whether slavery is constitutional. That issue was never considered by the court. The questions were presented were much more technical, and the easiest way I can try to explain it is it's very much like Somerset. What could emancipate a slave? Escape could not. The Fugitive Slave Clause said that. What about a temporary tour with your slave owner? What about residence? For a long time, the rule in this country was residence on free soil did emancipate. A temporary tour did not. But that issue was constantly litigated by the states, between the states, throughout the antebellum period. Prigg versus Pennsylvania is a case that fell right in the middle. Now, the story of Prigg versus Pennsylvania begins neither with Prigg nor with Pennsylvania, but with a young woman by the name of Margaret Morgan. She was a young slave of John Ashmore, a resident and citizen of Maryland. But Ashmore let her live in a state of virtual emancipation, though she's never formally emancipated. She doesn't get her papers, in other words. She marries a free black man, and they move to Pennsylvania and establish a family where they have some children. Now, all this is done with the apparent permission of John Ashmore. He never objects, but then he dies. He dies, and Ashmore's heirs are apparently not pleasant people, and they want to resecure Margaret Morgan and her issue, including young children born free in Pennsylvania, claiming them all to be part of the Ashmore estate. Now, Margaret Moore never gets to litigate the question of whether she's in fact been emancipated. She doesn't get to litigate the question that Dred Scott would litigate in the next decade. This is that story. The heirs hire bounty hunters, slave hunters. They go to Pennsylvania and they get the constable. Well, first they get a court to order the constable to arrest Margaret Morgan and her family. But the court refuses to issue a certificate of ownership as required by a federal statute, the 1793 Act, which tells you how you're supposed to get slaves who have, quote, escaped into a state so they can be returned. Now that's a setback for the bounty hunters. They need that certificate of ownership in order to comply with a federal statute. They don't get it. Now, Morgan's husband, who's free, is released from custody, but not the children. Despite the setback, Prigg and his gang of slave hunters take Morgan and her children forcibly back to Maryland, where she's resold and sent south, never to be heard from again. She disappears from this, really, her own case. Pennsylvania, however, secures Prigg, brings him back with 3 accomplices. They arrest him, they try and they convict him for violating an 1826 anti-kidnapping law. Prigg's convicted, but he appeals to the Supreme Court. The opinion is written by Justice Joseph Story. Now, he's anti-slavery. He writes the famous Amistad case. He's close friends with John Marshall, so he's a nationalist. What does he do here? What I was taught in law school was that he stands with his nationalistic principles, and he finds that federal law preempts state law under the Supremacy Clause. And so I was taught that this is just a straightforward application of a theory of constitutional nationalism. Had I been paying closer attention, I would have noticed that Chief Justice Taney concurred with Story, which should have been reason for suspicion. Justice John McLean tells the truth of the matter, and you should always remember that a dissenting opinion is worth reading, because you may get the real facts. He points out the Constitution is silent about how slave owners are to reclaim their slaves. The 1793 Act was supposed to explain that procedure, but Mr. Prigg did not comply with it. Justice McLean said, "I was not prepared to hear counsel contend that notwithstanding the Constitution and the federal statute, that the master could disregard the act, resort to violence and self-help, kidnap the individual, and return them back to Maryland." But that's exactly what the U.S. Supreme Court ruled. They invented a constitutional right of recaption, which allowed slave owners to hire bounty hunters and to go north and capture a number of individuals, claim that they were slaves, and bring them back to the South, including the free children of Margaret Morgan. It is a little-known scandal in the history of the Supreme Court. Nevertheless, the South wasn't very happy. The South has conned us all into believing that they are the great guardian of states' rights, that states' rights are always what the South was for. They were never really about slavery. But here is an example where Pennsylvania was relying on states' rights, and the South was trying to contend that they had a national right to the North's cooperation in the recapture of slaves. And they complained about it, they whined about it in their documents defending secession. It's an unfortunate decision, but one that falls into a pattern where the U.S. Supreme Court paid all too little attention to the basic human rights of African Americans prior to the Civil War. It was regrettably not a pattern that was changed with the Civil War. The second better-known case, at least in name, is Dred Scott. It also begins with a story, as all cases do. Dr. John Emerson was a surgeon in the United States Army. He took his slave, Dred Scott, to free soil, first on the free territory of Illinois State, and then on to the Wisconsin Territory, where he stayed at a place called Fort Snelling. That's where he was posted. It's still existing today as a National Historical Park in the vicinity of Minneapolis and St. Paul. Eventually, Emerson and Scott returned to Missouri, and Scott goes to Missouri state courts to sue for his freedom. He had a case on point. Now, some of you I know are lawyers. Neither you nor your sons will ever have a case as closely on point as did Dred Scott. In 1846, he was able to cite a case decided a decade earlier by the same court, the Missouri Supreme Court, where another Army officer took another slave, I kid you not, to Fort Snelling, Minnesota. And as a result of that case in 1836, Rachel versus Walker held that under Missouri law, slaves were emancipated by residents on free soil. But times had changed. Judges were elected. The South was angry at some northern abolitionist doctrine that had appeared in a number of states. And so they overruled Rachel versus Walker, decided that Dred Scott was still a slave and that he could not gain his own freedom. He then gets his case into federal court through a device, a few changes in ownership, diversity of jurisdiction. I won't go through the technical details. He basically argued that he was emancipated by virtue of his residence on free soil, 2 jurisdictions, and once free, always free, that Missouri lacked power to re-enslave him, if you will. The Dred Scott case is decided shortly after the inauguration of James Buchanan, and it basically asks the question whether Scott was a slave. It does not ask the question whether slavery is unconstitutional. Chief Justice Taney, in an opinion that's generally regarded as an opinion of the court, though the technicalities make it very difficult to be sure, rules that there's no jurisdiction because Scott is not a citizen. Scott is not a citizen because he's black, and Scott is not a citizen because he's a slave. Now, the first part of the opinion is filled with vicious, racist rhetoric, almost all of which I do not want to repeat here. But basically, he ruled that as a matter of constitutional law, blacks can never be citizens, and blacks have no rights with which white citizens are bound to respect. Now, he tries to defend this with a long, lengthy description of laws in the North. Some of his history is accurate, but his logic is not. It is true. There were lots of discriminatory laws, but that does not mean, and never has meant, that means you have no rights. Even James Madison acknowledged that slaves ought not to be murdered, raped, victims of theft, even under positive state law, that in the Federalist Papers. And most controversially of all, Chief Justice Taney ruled that the words of the Declaration of Independence, all men are created equal, never applied to black people. He then proceeded to say a number of things which actually became prophecies of progress. He said that if blacks were citizens, they would have rights. They would be allowed to move from state to state. It meant that they couldn't be the subject of special laws, neither slave codes nor black codes. It meant that they would have, horror upon horror, freedom of speech. And still worse, and this is for those of you who may have some sympathies with the NRA, they could carry firearms. They also ruled that Congress could not abolish slavery in the Western territories. This was the second time the Supreme Court overruled a decision of Congress. The first is Marbury, the second is Dred Scott. And if you go through the details of these 2 cases, the Supreme Court has not established a good record of wisdom in exercising this power of judicial review. In the words of a Pulitzer Prize-winning history by Don Fehrenbacher, the court majority, meaning the Taney opinion, appears incredibly unrealistic. indeed so foolish as to pour oil rather than water on a fire. They ignored clear explicit text, they ignored clear explicit tradition, they ignored the Northwest Ordinance of 1787, the Missouri Compromise of 1820, and the Compromise of 1850, all while ruling that everything that Congress did in those pieces of legislation were unconstitutional. They did one thing more. It's the good effect of the decision. They made Abraham Lincoln really, really mad. The lawyer from Springfield, Illinois, decided to go back into politics, and he introduces himself to the nation in the Lincoln-Douglas debates and then later in the Cooper Union Address, essentially writing, I'm not kidding here, a law review article. Now, this is hard for law review students to believe, but Abraham Lincoln introduces himself in February 1860 in a place called the Cooper Union in New York City by reading a law review article designed to show that Roger Taney ignored the original understanding of the framers. Lincoln's argument that the Declaration of Independence said what it meant and meant what it said was amplified into an argument that captured the hearts of a passionate group of anti-slavery citizens and eventually helped him get elected President of the United States. And from the conflict that followed, we got a 13th Amendment, a 14th Amendment, and a 15th Amendment. And the 14th Amendment's central purpose in Section 1 was to overrule the Dred Scott decision. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.